Good afternoon. Welcome to another edition of Legal Access. We get together each and every Thursday, and we do have some heavy rain falling in parts of the viewing area here, so hopefully you're staying dry no matter where you are. We're going to be talking about wills, trust, and estates today. That's our topic. So if you have any questions about wills, trust, estates, make sure you get those questions in today. We get those questions answered for you. Here on the panel to answer those questions, first of all, we've got Brittany Jones from the McGuire Law Firm.
Hey Dave, how are you doing?
Doing good. To your left, Melanie Breeden is here.
Hi.
And on the very end of the table, Brett Davis. Hey, Brett.
Hey, Dave. Good to see you.
Thanks for coming in today and braving the weather.
Yes. Absolutely.
We need the rain, though. We do need the rain.
Absolutely. And Melody, just go ahead and tell us a little bit about your firm and what else you might do besides wills, trust, and estates.
Sure. I've been practicing in the Myrtle Beach area for about 22 years, and I'm with Turner Paget, and I primarily do estate planning and probate, so wills, trusts, and estates, and guardianships and conservatorships as well.
And Brett, same question to you, your firm and what you work on.
Sure, Davis Law Firm. I'm a lawyer and also CPA, and I've got a tax practice. I do estate planning, probate, do some asset protection, Medicaid planning, VA planning for long-term care, those types of matters.
Now, we always tell people that they can email their questions in advance if you'd like to. Our email address here is legalaccess@WMBFnews.com. That's legalaccess@WMBFnews.com. We did have Laura who sent us an email from last week who wanted to be on the show this week but couldn't call in, but she is listening, at least that's what we understand. And if I can get up here to the top. All right, her question is that her mother died 7 years ago and her sister is the executor of the estate, or what we call a personal representative now. There are 6 of us to split the proceeds and the sale of the property, but the sister will not put the land up for sale. What can they do?
And that's a good question, and there's some things that it may depend on if there was a will in place and if the will authorized the personal representative to sell the real property. If not, they may need to actually have a petition filed with the probate court to grant authority for that personal representative to sell. Otherwise, the personal representative may just be distributing it to everybody. If everybody does receive it outright, there's a whole other set of types of litigation that could come from that as far as filing partition and other actions. But
And Dave, also there's a provision in our probate code which you can file to force a personal representative to do their job. And it sounds like this personal representative may be kind of dragging her feet. And so there are some provisions that allow you to file something or give you a way to file something to force the personal representative to do what they're supposed to do. Sounds like she may need to consider that.
I think, is that something that comes up? Sorry, David.
No, go ahead.
But it just made me think of, I know we hear questions a lot and send people to you guys to get them answered. But as far as, people almost arguing or fighting over who gets to be the personal representative because they want to decide what happens with the estate, and that is my understanding is that not really how it works, right? I mean, the PR is not really making decisions. Is that right?
And some of it depends on whether there is or is not a will, and if what the will directs. So if the will directs, then it gives the personal representative authority to sell. Most likely, as Brett said, they probably should be selling it, or they may need to bring an action to force the personal representative to sell. But the personal representative is carrying out the decedent's wishes, not really deciding who gets what, so to speak.
Like in your case, Brittany, I know you guys do a lot of personal injury. So you may have an estate where somebody died in an accident and may have been very young and didn't have a will because they didn't think they needed a will, and it's just an unusual accident. A lot of times in those cases, you'll have people that have equal priority to serve as personal representative. And you're right to an extent. If you're in the role of personal representative, you do have a certain amount of control and discretion you can have over what happens. So a lot of times people will sort of argue about who should be the personal representative of that estate because it will put them in the driver's seat to do that if they don't have a will.
Right.
If they have a will and they nominate somebody in the will, then that would normally control or influence the court to appoint that person that they nominate.
Okay.
That's a good question.
All right, staying with the executor or personal representative question here for Laura. What if in the will they designated that, okay, there's 6 of you, we want you to split the estate 6 ways. What if 5 of the people want to sell, but the 6th person says, no, I want to hold on to the property? What happens at that point?
I think the same kind of thing. They probably are going to need to bring an action to have the personal representative sell the property and/or buy the personal representative or the other parties out. It sounds like that's probably what needs to happen.
That's a great question, and it's a terrible question because it creates some issues. But the default is if the will says to distribute all the assets in kind and equally to all the beneficiaries, then that one that doesn't want to sell has a very good argument that the property has to be distributed out equally to all the beneficiaries, which creates another problem like Melody was talking about, because now they're going to have to file a petition action and force the other people to sell it if they don't want to. It's better to deal with that in the estate if at all possible.
Wills, trust, and estate, that's our topic here today. It's a very popular topic, so if you want to make sure to get your question in before the show's over in about 25 minutes, make sure and call us right now. The phone number's on your screen. It's 843-848-8080. Give us a call, and we'll get you right on the air, just like Richard in Myrtle Beach. Hi, Richard. Thanks for calling in. What's your question?
Yes, I was a lifelong resident of Pennsylvania, and I had our attorney up there draw up a will that leaves everything to my daughter. And now we moved to South Carolina. I'm a resident here. Is that will binding in South Carolina?
Well, we get asked that a lot, and the simple answer is it should be binding or it should work in South Carolina if it was validly executed in the state in which you resided at the time. The caveat to that is there often are nuances in South Carolina or the state where you're living, if you're living here now, that you may want to have that document reviewed. There may be other things or changes in circumstances of reasons you might want to update that. Also, you may want to have a look at your power of attorney and healthcare and see if anything needs to change on those.
Yes, I agree. Also, one thing I'm sure you see at Melody is some wills in other states will not have what we call a self-proving affidavit. They'll have the witnesses witness the will, but they won't have them attest to that before a notary public and self-prove it. So what that means is you have to produce the witnesses when someone passes to verify that will. Well, that's very hard. If somebody dies 20 years after they do a will, they can't find those witnesses. So you need to check and make sure that will has been self-proved before a notary to make sure you don't have some issue that may come up later.
All right, thanks, Richard, for calling in. Appreciate that. If you want to get on the air, like Richard, give us a call. The phone number is 843-848-8080. We'll get you on the air as we're talking about wills, trust, and estates here today. Now, one of the other big questions, in addition to what Richard said as far as other states' wills being valid, is like what happens in South Carolina if you die intestate, if you die without a will?
So without a will in South Carolina, a lot of people assume that all will go to a surviving spouse, but that's not the case. Our intestate provision is 50% would go to surviving spouse if there is one, and 50% to children. And that's of assets that go through the probate process, not things that have a beneficiary designation or are joint. So it's very important to know what to make sure that's what you would want or not want. And most of the time it's not. Most of the time they don't want things to go outright to the children, especially if you have minor children. So usually people think it would always go to the spouse, and it does not. And if there's no spouse, then you've got kids. And then if there's no kids, there's other provisions in there in the statute. But it's best to have a will so that you're designating what you want to happen instead of the state.
So what happens if they do have minor children?
Oh, if there's minor children and there's not a will, then you end up having to set up the conservatorship through the probate court until those minors reach the age of 18. Then whatever funds they're receiving get turned over to them at the age of 18, which is not always a good thing.
Right. Yeah, I feel like I hear sometimes people talk about, it might be expensive to get a will, and they want to avoid doing that, and they would rather it just go to their spouse and kids anyway. But that sounds like it would be very expensive.
It's a lot. It
actually.
can be a lot more expensive to
Yeah.
not have a will, especially
Right.
if you have minor children. Having to go through those processes with the probate court of having those extra steps is, in my opinion, more difficult than if they spend a little bit of money up front to do a will properly in the first place.
Yeah.
I feel like it saves a lot of time and money for them in the end, the family at least.
Absolutely.
Yeah.
Wills, trust, estates, that's our topic here today. Before we go to break, let's go to another phone call. We've got Lewis in Conway. Hi, Lewis. Thanks for calling in. What's your question?
Yes. Yes, hi. It's related to state planning. We're a couple of dual citizen, American Canadians. We're living outside of the United States for 30 years. So we recently moved back to the U.S., and we saw a property in Canada. We wanted to put the property into our kids' names. So what were the good strategies to either estate planning to pass it on the easy way, or whether government will see a 20-year-old getting a new home in their names, a little bit more suspicions? How do we do this process to pass wealth and accumulation of state to our kids?
Great question.
So, Dave, I've had a few clients that have been citizens of Canada or other countries, and that's tricky. Generally speaking, if we do documents here, it's going to control assets in the United States of America. You need to have a separate estate plan in Canada if they got assets in Canada. They actually do a probate administration there I think through the Notary Public. It's been years since I've worked with one. But I'm thinking he's asking, what do you do if you live here but you've got assets in Canada, if I'm hearing him correctly, and you're going to have a Canadian attorney draft up some kind of plan that will control those assets. And if I know another thing with Canadian citizens, if you've got American property and you sell it, you actually have to do a different thing from a tax standpoint, submit 10% of the proceeds regardless of what your gain may be, and then file a return later. So I think they said dual citizenships. I'm not sure if they've got a Social Security number, and they also have a Social Security number in Canada, but that creates a interesting set of circumstances. You really need to talk through that.
Right.
Right, yeah, that would be,
question.
I agree with Brett, though, you would need somebody both here and in Canada to be working with to make sure you're complying with everything that needs to occur here and there, and any potential tax laws or implications.
And kind of related to that, if they had, kind of just the estate planning question, if you have property here, he talked about possibly transferring it to, I think he mentioned a 20-year-old or something like that, as a way to, plan or pass it on to the next generation. Is that something that you guys would generally recommend, or what other ways to accomplish that?
Oftentimes, I might look at that idea through a trust, so that you're setting something up, because it may not be the best idea to have the 20-year-old, to transfer those things outright to the 20-year-old. Yes, there are some things you can gift to individuals that may not, that you may not have to report, or there are certain reporting requirements with gifts. But at 20 years old, there may be some other ways you want to do that, like through a trust versus outright.
Yeah, and also there's a lot of issues kind of embedded in this question. But another tax-related issue is if you give something to somebody during life, they get your old tax basis.
Right.
Whereas if they get it when you pass under Section 1014, they get to step up the tax basis. So a lot of times clients will come in and say, well, I just want to give my assets to my children now at the family farm, which they've got no basis in. I'm like, well, that's a terrible idea, because then when you pass away, your children could have stepped up that basis. So
Right.
I don't know if that was part of what he was asking or not, but it's generally not a good idea to give assets to your children while you're still alive.
Yeah.
And I know we talk about other risks
Yeah.
that we see, handling personal injury, is that it opens up that property to a lot
Right.
more liability as well, potentially.
Right. I mean, if that
Other
20-year-old is in an accident, or is gets involved in a lawsuit themselves, and that property is subject to that.
Right.
Whereas if the person had kept it in their name or set it up in a trust that they benefit from first, and then goes to the kids after they pass, it's a different situation.
Right. Yeah.
We're talking about wills, trust, and estates here today on Legal Access. Got a lot of questions to get to, and we've still got time to get you on the phone. If you want to give us a call, the number's on your screen, 843-848-8080. I know we have a couple of people on hold. We got to take a break here real quick. As soon as we get back, we'll talk to you about your questions about wills, trust, and estates here today on Legal Access. Welcome back. It's Legal Access. Today's topic is wills, trust, and estates. If you have any questions along those lines, the phone number's on your screen, 843-848-8080. Here to answer those questions, we have Brittany Jones from the McGuire Law Firm, also Melody Breeden and Brett Davis. Thanks for being here today and braving the weather. A little bit of rain in our area as we're doing the show here today on a Thursday. A lot of questions about wills, trust, and estates. As we've talked about some of the typical questions all the time. Let me go ahead and I'll let you pontificate here for a second. A lot of people say, why should I come to you? I can just do my will online. It's offered all over the place. What can you guys offer that an online service can't?
One of the biggest things that we actually are the legal advice that we're giving them, we're actually overseeing the entire process. We're making sure that everything they need is in the document, is properly executed, is properly witnessed, and it actually will carry out their objectives.
You want me to pontificate?
We do have limited time, but go ahead.
Yeah.
Okay, I can pontificate. Well, when somebody comes in to talk to you about their estate plan, Dave, they don't know what they don't know.
Right.
When we listen to the facts and listen to the family, we can oftentimes point out things we've seen with other clients, potential problems, or some things that they could avail themselves of that they may not know about, some benefits that they may have for some long-term care, or also talk through the tax implications of what they may be thinking. So that's the biggest thing, is that a lot of times clients just don't know what they don't know about the legal field, the wills and trusts. And that being said, sometimes there are some simple plans that they can, get some kind of simple documents, and doing it may work fine. You just don't know, unless you kind of go through that and see. And if somebody, they want to do that, They can, but they may be missing something.
Yeah.
And a little cost on the front end, I think. seems
It
very
typically
worth
does. I mean, and what I have seen is I've seen somebody who did something online, they thought they did it right, then they printed it out, but they didn't actually sign it, or they only signed it that wasn't witnessed, so it was pretty much worthless, or
Right.
it didn't do what they needed to. I had somebody who didn't name their personal representative. They didn't know they needed to. They just printed the form out and they signed it, and it really was useless. Or somebody who did their own power of attorney that said this is no longer effective if I become incapacitated. They became incapacitated. The people wanted to use it, and I said it's a worthless document. They said, why would anybody do this? I said, because they didn't know any better.
Yeah.
So if they had spent a little money on the front end, we would have saved thousands of dollars on the conservatorship guardianship side. Or same thing on the will contest if somebody didn't do it right.
All right, Granddaddy writes a will on a piece of paper, puts it in a mason jar, and buries it out in the backyard. He passes away. Is that a valid piece of paper?
Are we talking about South Carolina or West Virginia?
South
Yeah,
Carolina.
South Carolina.
Let me, and I say that sort of joking, but I'm serious. West Virginia does allow a holographic will. I had one that we probated in South Carolina. South Carolina does not allow a holographic will. And what holographic will means is if you write it in your own handwriting and just sign it, then it would be your valid last will and testament. In South Carolina, you have to have it witnessed by 2 witnesses, and if you don't want to have to prove the witnesses or provide the witnesses, you have to have it self-proved before a notary. So Granddad can do that, but he's going to have his farmer friends down the street come and witness it if he wants it to be valid. And you got to be able to open that mason jar when it wants it sits
Know
in
where
the
it's
dirt.
buried and all
Yeah.
that, yeah.
Do you get a lot of instances? Well, before we go to another break, we do have Randy on the line. Randy, sorry for making you hold through the break as we were pontificating here for a minute. Randy, what's your question for the panel here today?
Yes, I'm from Michigan, and my father passed away, and there's 7 siblings. Now, my mother changed the will my father established because she didn't think it was fair, and so she then made my youngest brother the executor of the state. Now, what they did. Okay, 2 of my brothers, they took that will and without everybody getting what they're supposed to have, turned it into a trust with those 2 on it, but not the other 5, without being contacted about the change from a will to a trust. Now, is that a legal maneuver, or, can he do that, or what?
Well, and I think some of it may depend. So if Dad left everything to Mom, and then Mom changed the estate plan when she had everything to create a trust that only left it to certain people, then Mom would have the right to do that. Now, if somebody changed Dad's documents after he died fraudulently, that's a different story. But if it went to Mom from Dad, then Mom has the right to do whatever she wants with it.
Also, one thing that comes up, which I don't really like in documents, but some powers of attorney will allow the agent to establish a trust for the principal. And I'm not a big fan of doing that because sometimes they can alter the plan. A lot of times, though, if that trust is not set up and consistent with what the will was, then I think they got an argument that the agent violated their duty and did something different. It sounds like here, without seeing the documents, we don't really know how that was done. So we don't know what may have been done incorrectly or what may have been done fraudulently. But it's kind of unusual for somebody to take someone else's will and convert it to a trust unless they've got a specific power of attorney that allows them to do that. Mm-hmm. Or if all the assets went to the wife, as Melody was saying, then she'd have the freedom to do whatever she wanted to do.
And we do see that a lot where one spouse leaves everything to the surviving spouse, and so that it's in the name of the surviving spouse, but the family says, well, Dad or Mom, whoever the first one to die, they set it up this way. Why doesn't that happen? Well, if it all goes to the surviving spouse, then it's the surviving spouse, and hers or his documents would be controlling.
Mm-hmm.
Randy, hopefully that helps you out. If not, you might need to get in touch with somebody to get a little bit further in depth in what's going on in your life there. But just like Randy, if you'd like to give us a call, our phone lines are open. The phone number's on your screen, 843-848-8080. We're doing the show on Thursday. If you're listening to it on the radio on Saturday, you can't give us a call because we're not here at that moment. But anyway, we got a few more questions answered and a few more calls to get to when we get back on our final segment as we talk about wills, trusts, and estates right here on Legal Access. Welcome back. It's Legal Access. We're talking about wills, trust, and estates here today on the show. We got a few phone calls to get to in the last 7 minutes or so we'll try to get them all in if we can. First of all, Mona is in Little River. Mona, hi. Thanks for hanging on through the break. What's your question today?
Hey, my question is, my aunt and uncle passed away, and they left their estate and everything to my cousin. And there's a team of law enforcement that had been watching the house for a couple of years after my aunt and uncle passed away, and they deemed my cousin got incarcerated. Well, I was contacted that a team was going to seize the house or let it go to the next heir. It had past taxes owed on it. Well, anyway, it was deemed a nuisance abatement. And so they contacted me because I was the next heir in line, and I paid all the fees and everything that was to be paid. And this team of detectives, they went to the prison, had told my cousin that either, he had a choice, he could, sign the property over to me, or they were going to seize it and donate it to an educational fund. My question is, my cousin now is telling me that they did that illegally, that's not allowed, because in that paperwork it says that he can never be back on the property. He can't even come back on the property. That is, the county has kind of like power of attorney out over the property for the next couple of years as well. They can come on the property
right.
at any time.
Do you guys have enough to...
There's a lot of stuff. There's a few,
Yeah.
a few different issues I can touch on. Well, if the person died and left it to that other person, even though they're incarcerated, they can still receive assets. Apparently, the real estate taxes had not been paid, and they were trying to comply with the statute for notice to sell the property at a tax sale. They were trying to notify all the properties, because that's how you set aside a tax sale if there was not proper notice. So they were going through all the mechanics to notify the people, and they apparently found her and provided some notice. She's got a couple of issues of whether there was proper notice and whether it was sold and whether it was properly reclaimed after it was sold from the tax sale, I think is part of what her question is. Mm-hmm. There's also another thing that she didn't mention that may have some application. Our probate code allows you to determine and deem, or have the probate court deem someone unavailable to receive assets from an estate for various reasons. Either you can't find them, or they're permanently incarcerated, or that's not necessarily a reason, but there may be some reasons to treat a person who otherwise is an heir or beneficiary as unavailable. Then assets would pass to the heirs at law. And as a cousin, she or a niece, she may have an interest as an heir at law. So there's a few issues kind of embedded in that need to be flushed out, I think.
Definitely worth sitting down with somebody
Oh,
and
yeah,
talking through
definitely.
that in more detail.
Yeah, Mona, there's a lot of prongs on that you need to get fleshed out, so you need to sit down with somebody that kind of sounds like. Let's go to Hartsville right now. Carol's on with us. Hi, Carol. Thanks for hanging on. What's your question today?
Hi. I appreciate you guys. I watch you quite a bit, and you are really good. Healthcare, living will, or however that's put for healthcare, and for like a medical power of attorney. How do you go about that, with doing that?
Can I ask her a question? Is she asking about how do you do a medical power of attorney, or how do you get control, the ability to make medical care decisions for somebody? Is that what I'm assuming she's asking?
Yeah, like if I go under surgery, hypothetically, if I go under surgery, should I have a healthcare living will and also a medical power of attorney?
Yes. So in South Carolina, we have a form now that combines those into one. It's called a South Carolina Healthcare Power of Attorney form, and it has all those provisions to do that. There's a separate document called a DNR, which people confuse with a healthcare power of attorney or a living will. That's where you don't want to be resuscitated under any circumstances, and that normally is done in the hospital.
Right.
But to answer her question, she just needs the one document called a healthcare power of attorney.
Yes, I would agree.
All right, well, Carol, thanks for your call here today. I know we got Autumn on the line with us right now. Autumn, sorry, we're not going to have time to get you on, but if you'd like to email your question to us, we can get it answered off the air. Our email address is legalaccess@WNBFnews.com, legalaccess@WNBFnews.com. Thanks for all the phone calls here today, and thanks for watching on a kind of a nasty day around the Grand Strand and the PD. Next week when we get together, we're going to be talking about real estate law. I want to thank Brittany Jones, also Melanie Breeden, and Brett Davis for being with us here today. I'm Dave Priest. We'll see you again next Thursday for Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please contact and retain an attorney in order to obtain case-specific legal advice.